power in the tongue. If that's true, I wanna take this time to speak life into you. I'ma help you overcome what you're going through. You're not in this alone, I was sent to put you on. You wanna see how good life is? All you really need is some guidance. The ones close to you may not like it. That's cool, cause pretty soon, them fools gon' see that you were a diamond. First of all, I wanna give praises to the Most High for giving me the strength to make changes in my life. Cause without me going through what I went through, how could I even have the wisdom to give you or lead by an example? So let me be your coach. You gon' need some advice when you get thrown against the ropes. I'ma keep you on your toes. I don't know if you know, but there are unseen forces battling over your soul. Who wins? Well, that depends on the choices that you make. My advice to you is choose life each and every day. That's easy for me to say when it's definitely not the case. It's tough when you got so much temptation thrown in your face. Okay, let's say if you fall by giving in, would you beat yourself up about it or get up and try again? Don't allow sin to be a burden. Accept it, learn from it, move on and keep working. They say it's power in the tongue. If that's true, I wanna take this time to speak life into you. I'ma help you overcome what you're going through. You're not in this alone, I was sent to put you on. You wanna see how good life is? All you really need is some guidance. The ones close to you may not like it. That's cool, cause pretty soon, them fools gon' see that you were a diamond. I'm a SC, I do things a little different. I be at peace, cause I stay in the spirit. I'm a blessing to all those who dwell with me. I'm not flexing when I say my life's litty. Love is what my foundation is built on. Everybody I connect with, the vibe be so strong. I'm vegan, so I got love for the animals too. They're my sisters and brothers, I do not look at them as food because I'm pro-life. I serve the God of the living, they be the most high. And anybody who don't like me, they'll be alright. They can keep that negativity on that side.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are. Right. That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes, yes. We will shut shit down. Blessings, blessings. Welcome to Uncensored Enlightenment Talk. And you're here with your host, Grace Levi. Yes, yes, yes. I want to say thank you to everyone who is tuning in for all of my uploads and all of my lives that I have been doing in the last few days. Shout out to Baby Solo. You're in the building. You've been here for it. And all of the mods that support this platform, Dolton, Grace Levi, Thornton, and the whole situation in itself, and whatever else content that I put up there. Now, today we're going to be following up on what we did yesterday, and we're going to have a full reading of the appellate decision related to the $33.5 million lawsuit that is not pending, but now is going to turn into a levy for the township of Dolton. Now, before we get to that, we do have an update. We do know the content of the lawsuit, the $33.5 million, right? No value? Can you hear me? Hold on 1 second. Someone said no value. For the township. Okay, I can hear myself. So maybe you need to restart your video. All right. So with that goes to say, Y'all know what the content was about. It was pretty disturbing last night as we listened to it. As I promised you guys, I separated the content so y'all can just listen to the court transcripts in itself. But we do have an update on another filed and pending lawsuit on Dolton related to the cops' abuse and behavior. So we're going to make that announcement, okay? But before we do that, I do have a few words for everyone. I do be creeping, and I pay attention to everything. And I have been paying attention to the Dolton Politics page. And what I do notice is that there is a tone of people from the town that feels that outsiders should not contribute to what's going on. Okay. There also was a post that highlighted that people who make videos on Dolton should contribute to Dolton. And I will say that I do believe that people who monetize and make money off of Dolton should contribute. But I do believe that is their choice, because we're not the only ones making content about Dolton. The same tone has to be given to the mainstream as well. We're just going to be honest. It takes a lot for people to actually do the research and bring comprehensive information to Dolton. This is going to be put up in Dolton's page because I want to introduce myself. My name is Lashley. I go by Nurse Lashley and or Grace Levi, Gracie, whatever you want to call me. On my particular platform, what I do is educate, empower, and I evaluate from a different perspective, okay? And it's uncensored most of the time. A lot of people are getting to know me, and now you're understanding my different skill sets as I show you more videos. This is what I like to do. This is what God has given me. I love to research law as well as finance. I like to make videos. I also like to talk and run my mouth and just ask those difficult questions. Now, again, I have to say this because this message is to the residents of Dolton and also to the Dolton Politics page, because I'm coming in like a spook. Like, where did she come from? You know, and I will say this again, my love and my thrive for the situation in Dolton is because I have experienced something similar coming from Newark, New Jersey, where our Mayor Sharp James was selling out the town with crooked behaviors. Now, it didn't get as bad as Miss Tiffany, Super Mayor Tiffany, rocking out with out. You know what I'm saying? But we have experienced that. I also been a part of a lot of grassroots movements in Newark, where you went out with the Stop the Violence, and we were literally in the streets every Saturday playing some of the music that I play for you, like "Wake Up Everybody, No More Sleeping in Bed." Excuse me, I got cotton in my ears, y'all. One ear still plugged. I can't hide it. Okay, it is what it is. Pray for Grace Levi. So we used to do that on Saturdays, go out with the bullhorns and say, you know, no more violence, things like that, trying to start the weekend in with a good vibe. Also, we had to put our feet down on our teenagers, making sure that they didn't bring drugs in our home, making sure that these things wasn't trafficked through our property. We were working with the police. We were doing things. So this is where my thrive is from, and this is where a lot of my suggestions come from. Just know, when I make videos that focus on facts. I give my opinion. I make you guys think from a different perspective. Excuse me, as well as I give suggestions. The suggestions are based on real life situation experience, and my quality assurance background as a legal nursing consultant, as a travel nurse. Okay. So I just want you guys to know what I'm coming in with, and it's not to take away from anything in Dolton. It's actually to give back. You know, financially, we already talked about, but what I'm going to do right now, you're going to hear a lot from me in this July, because I'm in the middle contract. So I'm off. That's why y'all actually seeing me more, and I'm just pushing out stuff, because this is what I like to do in between. I like to do it all the time, but I still have to work. So I work very hard, pay all of my bills myself. So I don't want you guys in Dolton, that think people are coming in to take over your movement, make money off of you, because a lot of the people who were doing that is actually from your town. So please evaluate that in the behaviors of the people that's there. Sometimes it takes people from the outside to see things different, and then come in with help factors. Nobody's coming to take over Dolton. So I just wanted to put that out there. I love you guys. Grace Levi is straight. I am, like I said, no matter what you say, I am your online resident. If you like it or not, right? I'm coming in hot. But we're going to come in with facts, detail-orientated lives, and y'all going to learn a lot, okay? So I hope you like the live that I did this morning. That's what I like to do, Miss Corny. I'm corny. That's what I like to do. Talk about taxes, finance, and all types of stuff. So thank you for allowing me to share that with you guys, and I hope you have learned. So before we get into the actual reading and the full transcripts, I am going to give you guys an update. So this update, I came across this article. This was okay. No, matter of fact, this is not a new article, but I came across this article, and I'm going to actually look for the lawsuit. Now, I don't know if this lawsuit is pending, and I want to ask you guys, can you find it? Because Alexis Wilson is someone that y'all talk about a lot in the comments. Alexis Wilson is somebody who I wanted to do a video on, but because I wanted to get a full understanding of the situation, because when you first look at it, you know how the mainstream will shape the narrative. So I was like, wait. And then I was like, wait, don't react yet. Just try to get more information. So allegedly, there is a lawsuit alleging excessive force by Dolton police in the shooting of the death of the 19-year-old. So in future broadcasts, this is what we're going to do as well. If this one is pending, we're going to get into this, and then it's going to help me get a better understanding of what happened that night, and if the cops did anything to the nature of what they did. And excuse me, guys. I'm still fasting. I'm cleansing, so mucus come up. Okay, I do apologize. That's what y'all be hearing when I'm clearing my throat. In this month, I'm cleansing, so I've been doing a lot of like ginger, garlic, and all that good stuff. So bear with me. So this is what I'm going to be looking for. If you got any information about this, please send it to me, because when I report on it, I don't want to be biased, and also I don't want to hurt nobody's feelings that much. You know, with something sensitive like this, I'm funny. I won't go in. But other stuff, y'all know I'm going to go in like a donkey. I'm going to ride it like a donkey, like prove it. But this, I want to evaluate it deeply and maybe talk about it from a different perspective, and then see if it's a pending lawsuit. Okay. So now we're going to get to it. You're not going to see me on the screen for most of this live. Okay. We're going to just put this video up. This was a video that was in the Dolton Politics page. Dolton Politics, y'all know I'll be creeping, so I'm going to be getting some of y'all videos, and we're going to be putting it up. And I'll be like, she took our videos. I'm going to give y'all the credit. And I'm a connect them to the post. But if YouTube ain't got it, and I find that it's funny or credible, or something that we need to know, I'm gonna put it on the screen. I'm just gonna let you know. So let's play this real quick, just to give you an update of what we're gonna actually be talking about today, or what you're gonna be listening to.
For NBC Fathers. On one of the village's bank accounts.
Okay, there we go.
Hundreds of thousands of dollars off limits.
We served a document on the village's bank that requires the document to freeze twice the amount of the
Hold on, y'all. Let me see if I'm having some technical issues. Can y'all hear me? Can you hear me? Okay, I was having a little bit of technical issues. We're gonna run around, back up. StreamYard does this to me from time to time. It kind of switches up. So let's play this. I'm gonna unmute my mic. That's what I have to do. Hold on. Let's start it from the top, guys. Thank you for telling me you could not hear. Thank you.
To an NBC5 exclusive, growing financial troubles in South Suburban Dolton. Failure to pay a debt has led to legal action on one of the village's bank accounts.
As NBC5's Regina Waltrip reports, this is just the latest problem for the community, as the mayor is the focus of a wide-ranging corruption investigation.
Allegations of misspending, bills not being paid. In the small south suburb of Dolton, residents and governmental leaders have been speaking out about these issues for months.
It's some trying times in the village right now.
Now, more financial troubles. Last week, legal action taken on one of the village's bank accounts, leaving hundreds of thousands of dollars off limits.
We served a document on the village's bank that requires the document to freeze twice the amount of the judgment. So in this case, the bank has frozen $440,000.
David Graham is a former Dolton detective.
I was there for 17
years. In 2019, he won a whistleblower lawsuit against the village. After several failed appeals, the village settled and agreed to pay around $220,000 in attorney fees and costs. Attorney Patrick Walsh says the action on the village's bank account taken because it is yet to pay, even after the village board approved payment.
The village agreed in a settlement agreement to pay these fees. The court awarded these fees, and now they're just not paying it.
A typical Dolton reaction for whistleblowers. They go against you, they retaliate against you, they're still retaliating today.
Tammy Brown is a Dolton trustee. She says it's unclear why the judgment has not been paid.
There's $809,000 in the account and $440,000 was frozen. That check was cut months ago. And why wasn't it given to that vendor? I don't know.
I hope that the courts will see that everything that's been going through and they award us that check so we can finally put this behind us.
We reached out to Mayor Tiffany Haynes' administration, but there was no response to our repeated requests for a comment. This matter heads back to court on July 23rd. Regina Walt.
All right. So that is the case synopsis. And what we're going to do now is get the reader on the screen. We're going to get the reader on the screen, so please bear with me while I set things up, okay? I appreciate you guys giving me a heads up that things were muted. Let's get it to it. Let's start from the top.
Limited circumstances allowed under Rule 23. This order was filed under Supreme Court Rule 23 and is not precedent except in the notice. 3rd Division. Order filed June 20th, 2024, no January 23rd, 0763 U-0763. Bifurcated plaintiffs will. Order presiding Justice Reyes and Justice Lampkin concurred in the judgment. Justice R. Van Tine delivered the judgment of the court. Limited circumstances allowed under Rule 23. This order was filed under Supreme Court Rule 23 and is not precedent except in the notice. 3rd Division. Order filed June 20th, 2024, no January 23rd, 0763 U-076323 IL App 4220. 5.01 was error. Plaintiff's counsel made improper comments during closing argument, and the trial court should have given defendant's proposed special interrogatory. Plaintiff Aya Seats is the special administrator for the estate of the late John Kiles, and plaintiff Sabrina Wright is the guardian of Dwayne Dunlap, a disabled adult. Plaintiffs sued defendant the Village of Dolton, among others, claiming that on October 9, 2016, police chase resulted in severe and permanent injuries and death to Dunlap and Kiles, respectively. A jury returned a verdict in Dolton's favor on plaintiff's willful and wanton claim and in plaintiff's favor on their claim of spoliation of evidence, which arose out of the loss or destruction of a police dashboard camera video of this incident. The jury awarded plaintiffs $33.5 million in damages. On appeal, Dolton argues that the trial court should have bifurcated plaintiff's spoliation claim from their willful and wanton claim. Plaintiffs failed to prove their spoliation claim. The the trial court erred by giving Illinois Pattern Jury Instruction 5.01. Plaintiff's closing argument was improper, and the trial court should have given Dolton's proposed special interrogatory. For the following reasons, we affirm. I background A initial pleadings and motion to dismiss plaintiffs filed this lawsuit in 2016. In 2018, Dolton filed a motion to dismiss pursuant to Section 2 to 619.1 of the Code of Civil Procedure, 735 ILCS 5/2-619. 1, which the trial court granted in part and denied in part. In 2019, plaintiffs voluntarily dismissed this lawsuit pursuant to Section 2 to 1009 of the Code of Civil Procedure. Plaintiffs refiled the case on November 5, 2019. Greenwood Road and Sibley Boulevard in Dolton, Illinois. Kiles and Dunlap were passengers in Sorrells's vehicle. Plaintiffs refiled the case on November 5, 2019. Their complaint alleged that at approximately 1 a.m. on October 9, 2016, Demetrius Sorrells was driving near the intersection of Greenwood Road and Sibley Boulevard in Dolton, Illinois. Kiles and Dunlap were passengers in Sorrells's vehicle. Dolton Police Sergeant Louis Lacey and Dolton Police Officer Ryan Perez chased Sorrells's vehicle at a high rate of speed for approximately 1 mile until Sorrells's vehicle crashed into the rear of a building. Kiles died at the scene and Dunlap suffered severe and permanent. Plaintiffs further alleged that Perez's police vehicle had a dashboard camera that recorded the chase. Plaintiffs served a preservation letter on Dolton Police Chief Robert Collins on October 17, 2016, and the court entered a preservation order on October 21, 2016. Notwithstanding the letter and order, Dolton never produced video from Perez's dashboard camera. Relevant here, plaintiffs alleged claims of willful and wanton conduct, negligent training and supervision, and spoliation of evidence. B. Trial. The case proceeded to a jury trial that began on July 26, 2022, and ended on August 3. 1. Lacey testified that he was on duty as a supervisor on October 9, 2016. At approximately a.m., he was driving southbound on Greenwood Road. As Lacey approached the intersection 1 with California Avenue, he saw a vehicle driven by Sorrells traveling northbound. Sorrells's vehicle slid through the stop sign at the intersection, then drove away. Lacey made a U-turn, activated his emergency lights, and attempted to conduct a traffic stop of Sorrells's vehicle for running the stop sign. By the time Lacey finished his U-turn, he could see Sorrells's vehicle at the intersection at Greenwood and Irving Avenue. Lacey also testified that Sorrells's vehicle was 3 to 4 blocks away by the time he completed the U-turn, and additionally claimed that he could no longer see Sorrells's vehicle at that point. However, Lacey also acknowledged that he could see all of Greenwood from California Avenue to Chicago Road because it was a clear night. You literally see the whole street. Lacey testified that there was no traffic that night and the roads were dry. As Lacey attempted to catch up to Sorrells's vehicle, he reached speeds of 71 to 75 miles per hour at the intersection of Greenwood and Irving. He testified that he had slowed to 25 to 35 miles per hour by the time he reached the next intersection, Greenwood and 144th Street. Lacey saw Sorrells drive into the oncoming lane of traffic and pass Perez's police vehicle. Lacey then saw Perez activate his vehicle's emergency lights and follow Sorrells. At trial, Lacey initially claimed that he lost sight of Perez's vehicle at some point, but upon being confronted with his prior deposition testimony, Lacey admitted that he could see Perez's vehicle at all times during this incident. As Lacey crossed 144th Street, Perez was ahead of him at the next intersection, Greenwood and Chicago Road. At Chicago Road, Greenwood becomes a one-way street called Lou Boudreau Drive, which ends in a T intersection at 142nd Street. Sorrells's vehicle was driving the wrong way down Lou Boudreau Drive and Lacey saw a cloud of smoke or dust. Lacey estimated that Sorrells was driving close to 100 miles per hour during this incident. Approximately 1 minute passed between Lacey making a U-turn and seeing the cloud of smoke or dust. Lacey testified that he did not know how long Perez had been on scene when Lacey arrived, but then admitted his prior deposition testimony that Perez reached the crash scene a few seconds before him was true. Lacey arrived at the location where Sorrell's vehicle crashed and saw two individuals attempting to flee the crashed vehicle. At least one was apprehended. Lacey then took charge of the scene and directed other officers to contact the chief of police, the commander, the day shift officers, and detectives. At some point later, Lacey learned that someone had been killed in the crash. Lacey testified that he was responsible for dashboard cameras being installed in Dolton police vehicles and that he oversaw dashboard camera maintenance. A dashboard camera is mounted to the front of a police vehicle and captures what the officer sees through the windshield. A dashboard camera begins recording audio and video automatically when a police vehicle's lights or sirens are activated and automatically uploads video recordings to a server when the vehicle returns to the police station. Lacey testified that he did not know whether Perez's vehicle was equipped with a dashboard camera on October 9, 2016. The following exchange occurred. If Officer Perez had a working dash camera in his car and he activated his lights, then video would have been created, correct? A. Correct. Q. And that video automatically would have downloaded to a server? A. It should have, if it was working properly. Q. All right. And that server is where? A. It's at the station. Lacey testified that he did not investigate whether Perez's vehicle had a dashboard camera because he did not know which vehicle Perez was driving. No one from the Dolton Police Department asked Lacey whether Perez's vehicle had a dashboard camera. Lacey testified that, generally, he would retrieve dashboard camera video from an incident involving a pursuit, but that this incident was not a pursuit. Perez testified that he was on patrol on October 9, 2016. Lacey was his supervisor. At approximately 1 a.m., Perez was driving northbound on Greenwood Road and saw Lacey pass him going southbound. When Perez was between Greenwood's intersections with Sanderson Avenue and Irving Avenue, he noticed flashing red and blue lights from Lacey's vehicle in his rearview mirror and saw headlights approaching him from behind at a high rate of speed. Perez then saw Sorrell's vehicle drive into the oncoming traffic lane, while passing him. Perez activated his emergency lights and sirens, maneuvered around another vehicle in front of him, moved into the oncoming traffic lane, and accelerated to catch up to Sorrell's vehicle. Perez never lost sight of Sorrell's vehicle but was never close enough to read its license plate number. Perez saw Sorrell's vehicle drive through stop signs at the intersections with Irving Avenue and 144th Street. Perez did not see Sorrell's vehicle crash, but he saw a cloud of dust and debris, which he assumed indicated that Sorrell's vehicle had crashed. When Perez arrived at the scene of the crash, he saw Sorrell's exit his vehicle and attempt to flee on foot. Perez exited his vehicle, ran up to Sorrell's vehicle, and apprehended him. Perez did not recall exactly when Lacey arrived at the crash scene but acknowledged that Lacey may have arrived a few seconds after him. Perez denied that he was ever on Mr. Sorrell's tail or that Lacey was ever right on tail. Perez initially testified that he did not recall whether his vehicle was equipped with a dashboard camera on October 9, 2016. However, upon being confronted with his prior deposition, started recording audio and video automatically when Perez activated his vehicle's lights and sirens. Any video the dashboard camera recorded would have been available on the vehicle's hard drive or uploaded to the cloud. Perez did not know whether his dashboard camera was working properly on the night of the incident but had no reason to believe it was not working properly. Perez did not know whether his vehicle's dashboard camera recorded video of this incident and had never seen such a video. He did not investigate whether the dashboard camera recorded any video because that was Lacey's responsibility as his supervisor. No one asked Perez any questions about his vehicle's dashboard camera video. Dolton Police Chief Collins testified that he spoke with Lacey and other officers on scene on October 9, 2016. He also reviewed police reports and GPS data relating to the incident. Collins testified that whatever video did exist did review, as he reviewed and preserved dashboard camera videos relating to all serious incidents. Plaintiffs introduced Sorrells' testimony via his videotaped deposition. Sorrells testified that on the night of the incident, he was driving and his friends, Kyles Dunlap and Kian Lee, were passengers in his vehicle. Sorrells turned onto Greenwood Road from Sibley Boulevard and saw a police vehicle make a U-turn behind him and activate its emergency lights. Sorrells accelerated and tried to flee because he had been drinking and did not have a driver's license. Sorrells did not intend to stop matter what the cops were doing. One police vehicle pursued him on Greenwood Road between the intersections with Sibley Boulevard and Chicago Road. Sorrells remembered seeing his vehicle on fire, being handcuffed in the rear seat of a police vehicle and no January 23, 0763. Feeling pain all over his body while at the police station. He did not remember running any stop signs or stop lights, how fast he was driving, crashing his vehicle, exiting his vehicle, running from police, being transported to or treated at the hospital, or leaving the hospital. Several days after the incident, Sorrells told detectives that the only thing he remembered was waking up in the hospital after turning onto Greenwood Road. J. Perzibila was qualified as an expert in forensic engineering and accident reconstruction. Perzibila analyzed global positioning system data from Lacey and Perez's police vehicles. GPS data reflected each vehicle's location expressed as latitude and longitude coordinates in 15-second intervals, and for certain triggering events such as sudden acceleration or deceleration. From that data, Perzibila mapped both police vehicles' locations and speeds during this incident, which he presented to the jury in a PowerPoint. The GPS data showed that shortly after Lacey made a U-turn at Greenwood in California and began driving north on Greenwood, his vehicle was traveling 51 miles per hour. Lacey accelerated to 77 miles per hour before reaching the intersection of Greenwood and Irving Avenue. Between that intersection and shortly past the intersection of Greenwood and 144th Street, Lacey was traveling between 63.1 and 78 miles per hour, with an average speed of 68 miles per hour. Between 144th Street and Chicago Road, Lacey's maximum speed was 56 miles per hour and his average speed was 29 miles per hour. The distance between the intersection of Greenwood and California and the crash site was approximately 0.8 of a mile.
Wow.
GPS data from Perez's vehicle showed that it was traveling at 30 miles per hour on Greenwood from the intersection with Sanderson to the intersection with 144th Street, slowing down at each intersection's stop sign. 3 seconds after Perez crossed 144th Street, his speed no January 23, 0763. Increased to 55 miles per hour. Perzibila opined that this increase in speed indicated when Sorrells' vehicle passed Perez. Between 144th Street and Chicago Road, Perez's maximum speed was 63 miles per hour and his average speed was 48 miles per hour. Perez slowed to 35 miles per hour as he crossed Chicago Road and then stopped at the crash scene. Sorrells' vehicle provided no GPS data. However, based on inferences from Lacey and Perez's GPS data, Perzibila estimated that Sorrells' maximum speed was 72 miles per hour and his average speed was 63 miles per hour. Perzibila opined that the dashboard camera video from Perez's vehicle would have been critical to showing how close the officers' vehicles were to Sorrells' vehicle. Dennis Waller was qualified as an expert in police practices. Waller opined Perez should have ensured that his vehicle's dashboard camera was working properly when he started his shift on October 9, 2016, but he did not. Lacey, as supervisor and the individual responsible for dashboard cameras within the Dolton Police Department, should have retrieved the video from Perez's dashboard camera, but he did not. Waller also opined that because this incident was a no January 23, 0763 significant event, Dolton police should have reviewed and preserved any video that Perez's dashboard camera recorded. Plaintiffs read the following stipulations into evidence. On October 21, 2016, the court ordered Dolton to preserve all dashboard camera video recordings and any other recordings made by Dolton police vehicles pertaining to this incident. On December 22, 2016, plaintiffs served Dolton with a request to produce all police vehicle video camera, dash cam records, and 4 documents and things, including all police video camera, dash cam records. Sabrina Wright testified to Dunlap's injuries and damages. Dolton called John Ryan, who was qualified as an expert in police practices. He testified regarding police practices related to vehicle pursuits. During his testimony, plaintiffs questioned Ryan about a screen capture from a dashboard camera video from a police vehicle driven by an Officer Bruno on October 9, 2016. The trial court admitted all exhibits the parties used during trial into evidence, including photographs of the crash scene, GPS data, police reports, and Perez-Ibila's PowerPoint. 2. Bruno did not testify at trial. However, plaintiff's complaint alleged that he arrived at the scene of the crash approximately 2 minutes after Perez. In closing, plaintiffs argued that Dolton failed to produce dashboard camera video from Perez's vehicle and offered no explanation for not producing it. Plaintiffs emphasized that Lacey was responsible for installing dashboard cameras in Dolton police vehicles. Perez acknowledged that his vehicle had a dashboard camera, and Dolton produced a dashboard camera video from Officer Bruno's vehicle. Dolton argued that Perez's dashboard camera video was not preserved because the incident was not a pursuit. Specifically, defense counsel stated, "It wasn't on anybody's radar screen to save a video."
Wow.
Did they save the other videos? Sure. I don't know why. That's never explained. There's nothing that varies about it, whatsoever. Dolton also argued that the missing video would not have shown whether Lacey's conduct was willful and wanton because he was driving behind Perez. The jury found for Dolton on the willful and wanton claim and for plaintiffs on the spoliation claim and awarded a total of $33,500,000 in damages. See post-trial motions following trial. Dolton filed a combined motion for judgment notwithstanding the verdict argued that the NOV in a motion for a new trial. The motion for judgment, NOV judgment. See post-trial. Court erred in finding that Dolton had a duty to preserve evidence. The Tort Immunity Act granted Dolton immunity as to the spoliation claim. The evidence did not support giving IPI. The court erred in refusing to bifurcate the willful and wanton claim from the spoliation. 5.01 claim, IPI 5.01 led to an inconsistent verdict, and plaintiffs failed to prove their spoliation claim. Dolton's motion for a new trial argued that IPI 5.01 misled the jury on plaintiff's burden of proof as to the spoliation claim. The court erred in refusing a special interrogatory that Dolton proposed, and plaintiff's closing argument was improper. In response, plaintiffs argued that Dolton forfeited its argument as to duty to preserve evidence. Dolton forfeited its argument as to immunity. The officer's testimony supported giving IPI 5.01. Dolton failed to timely request bifurcation. Dolton's special interrogatory was improper, and the trial court struck any supposedly improper statements in closing argument. The trial court denied Dolton's post-trial motions and Dolton timely appealed. 13. Dolton argues that the trial court should have bifurcated plaintiff's willful to analysis. 14. Plaintiff a duty to preserve the evidence. The defendant breached that duty by losing, or a plaintiff claiming spoliation of evidence must prove that the defendant owed the explained that. Our Supreme Court has destroying the evidence. The loss or destruction of the evidence was the proximate cause of the plaintiff's inability to prove an underlying lawsuit, and as a result, the plaintiff suffered actual damages. Martin v. Keeley and Sons, Inc., 2012 IL 113,270, 26. In this appeal, Dolton challenges the first 3 elements but not the 4th. 1. Duty to preserve evidence. Dolton first contends that it had no duty to preserve Perez's dashboard camera video. In Illinois, a court determines whether a party had a duty to preserve evidence by applying a two-pronged test. ID. The first prong asks whether such a duty arose by agreement, contract, statute, special circumstances, or voluntary undertaking. ID. If so, the second prong asks whether a reasonable person should have foreseen that the evidence was material to a potential lawsuit. ID. If the plaintiff does not satisfy both prongs, there is no duty to preserve evidence. Dolton v. The procedural history of this issue is convoluted. In 2018, the trial court granted Dolton's Section 2 to 619 motion to dismiss in part, finding that, to the extent plaintiffs alleged a duty to preserve evidence arising out of state law or police department procedures. Section 2 to 103 of the Tort Immunity Act granted Dolton immunity from suit. However, plaintiff's spoliation claim ultimately survived the motion to dismiss. Neither party moved for summary judgment on this or any other issue. During trial, the parties sporadically argued about whether Dolton had a duty to preserve evidence, but, as we will explain below, the court did not rule on that issue. Rather, the jury was asked to decide whether Dolton had a duty to preserve evidence and found that it did. In ruling, the question of whether the village of Dolton had a duty to preserve dashcam videos, that duty is always a question of law. But that was not an accurate statement of Dolton's post-trial argument. Rather, Dolton argued that the court found a duty to preserve and then improperly submitted the spoliation claim to the jury. Dolton's argument on appeal is that, at trial, the court reversed its own motion to dismiss ruling and found that Dolton had a duty to preserve evidence based on Collins and Lacey's testimony about the Dolton Police Department's evidence preservation procedures and policies. The record does not reflect that the trial court made any ruling on Dolton's duty to preserve evidence. The court considered the issue of duty to preserve at several points during trial. During the July 25, 2022, hearing on motions in limine, the court took under advisement the issue of duty to preserve and asked the parties to provide case law on that matter. On July 27, while discussing what the parties could mention in opening statements, the court indicated that it was not sure that there's special circumstances that rise to a spoliation claim, but that it needed to hear the evidence on that issue. The following day, the court stated that it had not ruled definitively on a defense motion in limine regarding the spoliation claim and again deferred ruling until the parties presented further evidence. On August 1, the court decided to give IPI 5.01 over Dolton's objection that there is no duty to preserve. The court correctly explained that IPI 5.01 does not include an element of duty to preserve and that IPI 5.01 and a spoliation claim are two separate and distinct things. The court also questioned whether the duty to preserve evidence ought to be a statutory duty and said it would look at the cases again. The court concluded the August 1, 2022, discussion by saying, "Let me pass on the Note January 23, 0763. On August 2, the court deferred ruling on Dolton's motion for a directed verdict on the spoliation claim. Immediately thereafter, in anticipation of plaintiffs resting their case, the parties argued about admitting plaintiff's preservation letter as evidence. The court initially indicated it would admit the letter and stated, "I think the letter is the catch-all. And I looked at the case law last night, and I don't think that is the trigger point here. I know that you want it to be, but I don't think that's the trigger point. I think you've got one, you've got Officer Lacey's testimony, and Officer Collins' testimony creates a duty, and two, I think you have special circumstances here." The Dolton Police Department in the ordinary course of business investigates and maintains evidence for potential litigation, albeit primarily criminal, but they know civil suits happen as well. And these are special circumstances that create a duty. It's foreseeable that there would be criminal litigation and potentially civil litigation when you have a crash like this. The department understood that this was significant. There was a press conference. And like I said, the police department, that's what they do. They investigate and maintain evidence. This discussion ended without a ruling. The court concluded by saying, You may think about how I'm going to deal with this, and let's get going with the morning. The parties then proceeded to defendant's case in chief. On August 3rd, Dolton stated that it wanted to preserve the record since there wasn't a court reporter yesterday afternoon when we chatted and object to the spoliation claim going to the jury. The court responded, after hearing the evidence, I think there's a spoliation claim. In all these proceedings, we can find no ruling by the trial court that Dolton had a duty to preserve Perez's dashboard camera video. At most, the exchange on August 3rd referenced an off-record discussion the day prior that may have included a denial of Dolton's motion for directed verdict on the spoliation claim. But we cannot speculate as to what occurred in off-the-record discussions. See Webster v. Hardman, 195 L2D. What the record does reflect is that the jury decided that Dolton had a duty to preserve evidence. The jury was ultimately instructed that, to find in plaintiff's favor on the spoliation claim, it had to conclude that Dolton had a duty to preserve the dashcam video from Officer Perez's police vehicle. The jury found for plaintiffs on the spoliation claim, so the jury necessarily found that, under the facts as they decided them, Dolton had a duty to preserve evidence. The trial court's ruling on Dolton's post-trial motions also confirms that the jury, not the court, resolved the issue of duty to preserve. That ruling stated that the court submit to the jury the question of whether the village of Dolton had a duty to preserve the dashcam videos. The issue with this approach is that the existence of a duty is a question of law for the court to decide. The issues of breach and proximate cause are factual matters for a jury to decide. Nunez v. Diaz, instruction that tasked the jury with deciding that question, 92 L2D 13. 18-19 Pelham v. Griesheimer WL 373177, * 10, citing 2008. 2. Breach Dolton also instruction that tasked the jury with deciding that question, did not propose an alternate instruction whether Dolton had a duty to preserve evidence. Dolton did not object to the spoliation jury. However, Dolton has forfeited any claim of error arising from allowing the jury to decide. Motion to dismiss. As explained above, during trial, the court did not rule on the issue of duty till we disagree with Dolton's suggestion that the trial court reversed its own ruling on the 2023 IL Act 211,327. 2. Breach Dolton also challenges the second element of spoliation, breach of the duty to preserve evidence. In the context of spoliation of evidence, breach means that the defendant did not exercise reasonable care in protecting and preserving the evidence. When a party in a civil trial contends that the jury's verdict was against the manifest weight of the evidence, we will only set the verdict aside if the opposite conclusion is clearly evident or where the findings of the jury are unreasonable, arbitrary, and not. Dolton first raised its sufficiency of the evidence argument in its motion for judgment NOV and now raises it in the context of its appeal from the denial of its motion for judgment NOV. We review the trial court's ruling on a motion for judgment NOV de novo, meaning that we apply the same standard as the trial court. Harris v. Thompson, 2012 IL 112,525, a motion for -22. Favorable to the opponent, so overwhelmingly favors a movement that no contrary verdict based on should only be granted when all of the evidence, when viewed in its aspect most. NOV judgment. -23. That's what I gave in my deposition bottom. 21-24. Then you stand by that answer? Q. I'm going to give you page 142, and you see if you stand. Perez's dashboard camera finding in plaintiff's favor on their spoliation claim. We reach the same conclusion, which is that the evidence was sufficient to support the jury's. However, he acknowledged no video could exist. At trial, Perez testified that he did not know or remember whether his police. The first question is whether Perez's police vehicle had a dashboard camera. If it did not, Perez's dashboard. That was the only trial evidence that Perez's police vehicle had a dashboard, that he testified at his deposition that his vehicle did have a dashboard camera and that that vehicle was equipped with a dashboard camera on October 9th. Q. Is this a subject you've thought about? That was the only trial evidence that Perez's police vehicle had a dashboard, that he testified at his deposition that his vehicle did have a dashboard camera and that that vehicle was equipped with a dashboard camera on October 9th. Q. Is this a subject you've thought about, whether your car had a dash cam or not? A. One or not? A. I mean, not something I've thought about. But, I mean, I don't know if it had. Deposition? Deposition? And we don't have the video, but I'll read it. Page 142, lines 21 to 24. A. All right. Do you remember giving this answer to this question at your? From the Q. Was it true? A. Yes. Question to you, did you give that answer under oath? And your answer was, correct dash cam, correct. You were asked in 2019 if your car had a dash cam, and you said correct, A. At the time, I guess so. From this testimony, a jury could reasonably conclude that Perez's vehicle did in fact have a dashboard camera on October 9, 2016. Dalton argues that plaintiffs could not use Perez's deposition testimony substantively and that the above exchange was merely impeachment, i.e., this testimony did not constitute evidence that Perez's police vehicle had a dashboard camera. See Van Steenberg v. General Aviation, Inc., 243 Ill at 3D 299, 328. B. Existence of the dashboard camera video. The next question is whether Perez's dashboard camera recorded video of this incident, and if so, what it recorded. Lacey and Perez both testified that dashboard cameras automatically activated his vehicle's lights and sirens just after Sorrells's vehicle passed him on Greenwood north of 144th Street. Perez testified that he followed Sorrells northbound on Greenwood Road and that he never lost sight of Sorrells's vehicle. Perez saw a cloud of dust or smoke from where Sorrells's vehicle crashed, then saw at least one man attempt to flee the vehicle on foot. It is reasonable to infer that Perez's forward-facing dashboard camera captured what Perez saw, i.e., Sorrells's vehicle driving on Greenwood Road north of Chicago Road, dust or smoke from the crash, and the immediate aftermath. There is no indication that Perez manually turned off his dashboard camera, and there is no suggestion that the camera malfunctioned. Although the evidence of what Perez did in the hours after the crash is sparse, it is reasonable to infer that he returned to the police station at some point. Lacey testified that dashboard camera videos are automatically uploaded to a server when a police vehicle arrives at the station, so it is reasonable to conclude that Perez's dashboard camera video most likely ended up on that server and was available to Dolton police. Perez's testimony suggested that the video was also accessible on his vehicle's hard drive. Accordingly, the evidence sufficiently established that Perez's dashboard camera recorded a video of this incident, which was available to Dolton police. See lack of efforts to preserve the dashboard camera video. The next question is what steps, if any, Dolton police took to protect and preserve Perez's dashboard camera video. Perez testified that Lacey asked him no questions about dashboard camera video recordings. The jury heard that, 12 days after this incident, a court entered an order requiring Dolton to preserve evidence related to it. Yet Dolton never produced the video. There is no dispute that Dolton police can retrieve dashboard camera videos. In this case, Dolton retrieved and produced a dashboard camera video from Bruno's vehicle. It is reasonable to infer that Bruno's dashboard camera functioned the same way as Perez's, saved video for the same length of time and in the same manner, uploaded video to the same server at the same police station, and was subject to the same departmental procedures regarding recovery and preservation of video. Dolton police not only investigated whether Bruno's dashboard camera recorded video of this incident, but also recovered and produced that video. Yet they did not take any of the same steps with respect to Perez's dashboard camera. That evidence supports an inference that Dolton could have recovered Perez's dashboard camera video but instead either allowed it to be deleted or simply did not produce it in this lawsuit. The totality of the evidence supported the following factual findings. Perez's police vehicle was equipped with a dashboard camera on October 9, 2016, which began recording video when he activated his lights and sirens on Greenwood north of 144th Street. Perez's dashboard camera captured a video of Sorrells's vehicle driving northbound on Greenwood and then onto Lou Boudreau Drive, and, at a minimum, a cloud of dust or smoke from the crash. That video was available to Dolton police. Nevertheless, Dolton police did not investigate whether Perez's. That is the opposite of this case in which, apparently, nobody investigated whether Perez's dashboard camera created a video or uploaded it to the server at the Dolton police station. 3. Causation. Dolton also challenges the third element of spoliation, causation. The third element of spoliation requires proof that the loss or destruction of the evidence caused the plaintiff to be unable to prove an underlying lawsuit. Video evidence is extremely persuasive. 162,430, 51, because it has also imposed a general requirement that when any law enforcement agency makes police vehicle video and audio recordings in connection with law enforcement or investigative duties, the recording must be retained for at least 90 days. And cannot be destroyed without a court order when they are evidence in a civil or criminal case. ID 32. In this case, a video of the final stage of the chase would have been an important and persuasive piece of evidence. The video would have depicted Dolton police pursuing Sorrells down Greenwood Road and onto a narrow one-way street in the direction of oncoming traffic approaching a dead-end T intersection.
Wow.
While the jury knew that these events occurred, the jury was not able to see how they occurred. Perez's dashboard camera video would have shown real-time traffic, lighting, and weather conditions during the chase, as well as any obstructions or hazards near the path of the chase. The video could have undermined the officer's insistence that this incident was somehow not a chase or pursuit. Most importantly, as Perez Ibila explained, police vehicles' GPS data could not depict their position relative to Sorrells's vehicle, which would have been critical and captured by the dashcam video from those patrol cars. 3. Dolton's opening brief concedes this point. At most, any dashcam would have captured footage based on Perez's vehicle in space and time to Sorrell's vehicle, not vehicle at a safe distance that would have allowed Sorrells to slow down and stop without a rear-end crash, or whether the officers were in overly tight proximity to Sorrells's rear bumper. The GPS could not have captured what the video would have shown. Dolton's suggestion that Perez's dashboard camera video would have shown nothing of importance because he was in front of Lacey is unpersuasive. Perez's video would have shown a clearer depiction of the chase as outlined above. In addition, the GPS evidence indicated that Lacey was close behind Perez during the final segment of the chase, between 144th Street and Chicago Road. Dolton's attempt to portray Perez and Lacey Perez's supervisor as two totally independent actors strains credulity. Without the video, the officers were able to paint a virtually uncontested picture of this incident, which is presumably why the jury found in Dolton's favor on the willful and wanton claim. The jury was instructed that determining whether Lacey's conduct in pursuing Sorrells was willful and wanton required deciding whether he acted with utter indifference to or conscious disregard for the safety of others. That was a fact-specific determination, and if the jury had been able to view a real-time video of the final part of the chase, there is a reasonable probability they would have found in plaintiff's favor on the willful and wanton claim. Accordingly, we hold that the jury's finding for plaintiffs on the spoliation claim was not against the manifest weight of the was not warranted. Dolton next argues that the trial court erred by giving IPI 5.01. See IPI 5.01. Evidence that is within that party's power to produce. The jury may infer that the evidence would do as the missing evidence instruction because it instructs the jury that, if a party fails to offer IPI 5.01 is often referred. Elements, cam video would be adverse. Elements, cam video would be adverse to the Village of Dolton if you believe each of the following, namely dash cam video from Officer Ryan Perez's vehicle. You may infer that the dash if the Village of Dolton has failed to offer evidence within its power to produce. The dash cam video from Officer Perez's vehicle was under the control of the 1. Element, 2 Village of Dolton and could have been produced by the exercise of reasonable diligence. Offered the dashcam from Officer Perez's vehicle if he believed it to be favorable to him. No reasonable excuse for the failure has been shown. We review a trial court's decision to give a jury instruction for an abuse of discretion, which considers whether, taken as a whole, the instructions fairly and correctly stated the law and were sufficiently clear so as not to mislead the jury. Dolton challenged the trial court's decision to give IPI 5.01 in both its post-trial motions. Under any standard of review, we find no error in the trial court's decision to give IPI 5.01. As explained above, the evidence supported the conclusion that Perez's dashboard camera recorded video of the most important part of the chase, that the video was available to Dolton police, and that Dolton police either allowed the video to be deleted or did not produce it. Dolton's explanations for its non-production of the video shifted over the course of this case. Prior to trial, Dolton claimed that the video had been automatically deleted 16 hours after the incident. However, Dolton abandoned that theory at trial. At his deposition, Lacey suggested that Perez's dashboard. For when the question is whether the jury instruction at issue accurately conveyed the applicable law, our standard of review is de novo. Camera did not record video because Perez did not log into the dashboard camera system. But at trial, Lacey testified that the dashboard camera recorded automatically without requiring a login. Ultimately, Dolton offered no explanation for the video's absence. In closing argument, Dolton's counsel appeared to acknowledge that Perez's dashboard camera video existed at one point but offered no explanation for what happened to it and expressly stated that he did not know what happened to Perez's dashboard camera video. These changing positions and ultimate lack of explanation supported the conclusion that Dolton had no excuse for the video's absence. Therefore, IPI 5.01 was warranted. Dolton contends that the trial court erred by giving IPI 5.01 without a limiting instruction that the adverse inference applied only to the willful and wanton claim, not the spoliation claim. Dolton suggests the jury applied the adverse inference of IPI 5.01 to the spoliation claim and simply presumed that plaintiffs had prevailed on that claim without considering whether plaintiffs met their burden of proof. In any event, Dolton has forfeited this argument. In the trial court, Dolton objected to giving IPI 5.01 and objected to the jury being instructed on the spoliation claim, but it never argued that giving both instructions would allow the jury to presume plaintiff's victory on the spoliation claim. We exercise all reasonable presumptions in favor of verdicts being consistent and will not find a verdict to be inconsistent if any reasonable hypothesis supports consistency. McQueen v. Green, 2022 IL 126,606. Dolton insists that the jury found that plaintiffs did not prove their willful and wanton claim even with the adverse inference acting as a substitute for Perez's missing video, but also found that Perez's dashboard camera video was necessary for plaintiffs to prove their willful and wanton claim. Which is why the jury found for plaintiffs on spoliation. We do not know whether or how the jury applied IPI 5.01. The jury was instructed that it may infer that the dashcam video would be adverse to the village of Dolton. It is possible the jury did not make that inference and simply decided they did not know enough about what happened during the chase to find for plaintiffs on the willful and wanton claim. Such a conclusion would be consistent with a spoliation verdict finding that Perez's dashboard camera video was the piece of evidence that would have allowed the jury to find in plaintiff's favor on the spoliation claim. Dolton's arguments on this issue stem from a misconception that IPI 5.01 created a mandatory presumption about Perez's dashboard camera video. It did not. The instruction merely no January 23, 076. An inference allows but does not require the fact finder to reach a certain conclusion. ID. By our Supreme Court has declined, in spoliation cases, to create an evidentiary presumption that a defendant's loss of evidence automatically deprived the plaintiffs of their lawsuit. Void. 100. D. Plaintiff's closing argument. Dolton next contends that plaintiff's closing argument was improper. In closing argument, attorneys have wide latitude to comment and argue based on the evidence and to draw reasonable inferences from that evidence. Sikora v. Parekh, 2018 IL App 172,473, 60. However, Attorneys cannot unfairly appeal to a jury's emotions because the jury must decide the case based on the evidence unencumbered by appeals to its passion, prejudice, or sympathy. ID allegedly improper comments must be viewed within the context of the entire closing argument. ID. We review issues concerning the prejudicial effect of potentially improper closing argument for an abuse of discretion. Dolton claims that the following comments in plaintiff's closing argument were improper. Counsel's argument that he don't have to prove anything. Counsel's statement that Perez said under oath, I had a dash cam. Counsel's claim that Collins said, I saw it and I preserved it. And counsel's argument that Lacey called in the remember, he called in the chief, he called in the detectives. I just killed somebody. We have to get to the bottom of this. The first thing he does is watch the dash cam video. It's really that simple.
Wow.
If it was good for him, we'd have it. I guess it wasn't good for him because we don't have it. Dolton did not object to any of these comments during closing argument, so it has forfeited these claims of error on appeal. See Bobby Kian v. Mraz, 2011 IL App 100 and Dolton also makes a generalized claim that plaintiff's counsel's improper argument was designed to excite prejudice in the minds of the jury against his adversary and that counsel made efforts to inflame the sympathies, passions, and prejudices of the jury were effective. Especially in the context of the damages award of the estate of John Kiles. Dolton does not identify what comments were allegedly improper and has therefore forfeited this claim of error. To be clear, we understand Dolton's claim of cumulative error. According to Dolton, because the trial court did not instruct the jury that it could consider the adverse inference of IPI 5.01 only as to the willful and wanton claim, plaintiffs were able to argue that IPI 5.01 meant they automatically won the spoliation claim. Dolton argued that the jury found for plaintiffs on 39. IL App 3D 62, 67.
Hold on 1 second.
3. Special interrogatory reject Dolton's claim of cumulative error. That special interrogatory read, was Demetrius Sorrell's conduct in driving finally. Dolton argues that the trial court should have given a special interrogatory that, disregarding several traffic control devices, and failing to curb his vehicle the only under the influence of alcohol, driving without a valid license, exceeding the speed limit, Dolton proposed that within the discretion of the court, the jury may be asked to find specially upon any material Section 2 to 1108 of the Code of Civil Procedure, provides proximate cause of the plaintiff's injuries, disregarding several traffic control devices, and failing to curb his vehicle the only under the influence of alcohol, driving without a valid license, exceeding the speed limit, Dolton proposed that within the discretion of the court, the jury may be asked to find specially upon any material Section 2 to 1108 of the Code of Civil Procedure, wanton claim without this special interrogatory, so we can safely assume that Dolton also with this argument pertains to the willful and wanton claim. Dolton prevailed on the willful end. Cress v. Recreation Services, Inc. have prevailed with it. Dolton's special interrogatory even assuming that Dolton was somehow prejudiced by the absence of this special. We cannot see what this special interrogatory would have essentially restated the element of proximate causation, which the willful and wanton claim interrogatory, we find no abuse of discretion by the trial court. We cannot see what this special interrogatory would have. Accordingly, we affirm the trial court's decision to refuse Dolton's have caused confusion about why the jury was being given two separate instructions on proximate added to the jury's understanding of the law. Affirmed. For the reasons set forth above, we affirm the judgment of the Circuit Court of Cook County. 3. Conclusion special interrogatory. Causation on the same claim.
All right, y'all. So that was actually the full read of the appellate court decision to reinforce their not the appellate court, but the $33.3 million lawsuit that is against the village of Dolton because of this man on the screen, as well as what falls on the record in the insurance of Dolton. All because of this man right here. Let me remove him off the screen. I want to just sum up some of the arguments or the findings that they were trying to basically sum up if you were confused. One of the things they were going on was that the defendants or the people bringing a lawsuit, let's say the plaintiff, did not have evidence, did not preserve evidence. So basically, they found under 501 that the evidence was supposed to be preserved by Dolton Police Station. And by them doing what they did, giving inconsistent statements, saying, hey, it cut on automatically, the camera cut on automatically when the sirens cut on, and then saying he didn't know if he cut it on, he didn't check his camera. Lacey didn't check Perez's camera. They didn't go to try to preserve the evidence. That was thrown out because you can't expect that the person who is bringing the claim to have the evidence if it's in your possession. So the ruling was halfway at that time, but they thought they were going to run with it, and that did not happen. Then they went on to try to say that the closing statement was sensationalized because they highlight that they lost that first motion to preserve evidence, and that should not have been in the closing statement, allegedly. But that is all part of the actual trial paperwork. So the judge said, no, we're throwing that in its face. Also, what else they went on to say, it was just a few more things, that the last thing they tried to do was throw the lowest blow and actually blame the person who did it. Now, I will say that I don't suggest people to drink and drive, to hit the pedal to the metal, to run lights. But there is a certain discretion that law enforcement should have, and they did not have that discretion. If they would have stopped pursuing that man, it wouldn't have happened. Okay, at the end of the day, they could have got that person's license, and tracked them down and then proceeded more safely. Okay, so that was the appellate court decision related to the $33.5 million verdict. It is affirmed. Now, what we're going to do is continue to highlight all these significant issues that are happening financially in Dolton this week. As y'all know, I did Thornton last week. If y'all didn't see it, go look at all the paperwork that I went over, all their financials, compared and contrast, and I gave Thornton a whole bunch to ask next time at that meeting. That meeting should not be 5 minutes, okay? Watch that video again, Thornton. So since it's so hard for me to get actual information related to Dolton finance, the spending, all of that should be transparent. I'm doing my own investigation and looking through all of the videos, listening closely to what they say. And we're going to do a comprehensive video on that for you coming up this week. I want to say this. I love Thornton and I love Dolton. That's why I give so much hours. Who the heck could be online for 3-4 hours unless they ain't got no live? Shout out to B&B. Let me stop. I had to throw a low blow. But because right now I am off contract, I have a lot of hours to give to you guys. And I love to make videos and I love to teach. So that's what you're going to get from me for the next 22 days until I find another gig. So what we'll be having coming up tonight is just basically the video that we showed you yesterday where we react to Belcher and Norwood going ham on Missy right here. We're going to actually just clean up that video for you and let that run out all of the greatest hits of our favorite trustees who keeps the fight going, keeping the hope alive. Again, we have people who want to see, let me put them on the screen, wants to see this man in position. So if you do support him, definitely go about it the right way. Start your campaigning now. Make sure that, I'm going to say it too, Mr. House have the priority of the people. What is he going to do? Make sure, I love you, Mr. House. You are my booski because you're really a nice guy, but you better make sure you have a backbone because you're going against devils like this, okay? So you did really good in the last meeting. I just wanted to highlight that. He was nice, cool, calm, collected, looking around, doing his little thing. But just make sure that you continue to hit them hardcore, just like our lovely Black women. I'm going to give it to them because they say we attacking Black women, Miss Norwood, and shout out to Miss Belcher. So I hope that you like the read. I had to, do some things to make sure that it was smooth for you guys. And y'all will see me later on this week. I have a lineup. Y'all have so much going on in Dolton. Now, just know that it ain't no gossip in here. We're bringing the facts. We're giving a little bit of my spicy opinion, critical thinking from the left side, and we're going to give suggestions. So I want to say I love you guys. Thank you to all of the moderators here. I will actually see you live on Wednesday nights. I have a surprise for you. Y'all know I always got some damn surprise. I got a surprise for you. All right, let's put a Hebrew artist on the screen. Listen if you would like. Get the message behind what my man is saying. Torah number 2.
Yeah, hatred and envy, don't let it tempt me. I move defensive. Evil offends me, I yell repentance. We come from trenches. I'm in the secret place of the Most High, you can't offend me. Hamashiach built many mansions, that's where my rent be. Father, help me overcome. People who I used to look up to, they turning foes for none. Father, you my strength and you my courage. I feel bold for some. I wanna feel your spirit on my body like it's clothes or something. Put my vision in your one direction like it's froze or something. I can feel the hatred in their heart is like a arm song. Yeah, they full of nerves like my hands or my toes or something. No nervous system, but you know I feel it like I'm
every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans to run for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Would you like to learn a brand new and innovative way to invest your extra money that has a low barrier to entry and low competition? What if I told you that it is a guaranteed method to get up to 18 to 20% return on your investment? Tax lien and deed purchasing is the only way to get into the real estate market through the back door. No credit and no loans needed. This method isn't commonly taught, and therefore the competition is very low, for now. Put together a 14-hour info-packed course which will teach you everything you'll need to know to get started. Learn at your own pace, step-by-step guided video and aids to start you on the TLC deed investment process. The course offers many learning tools for new investors, helping ensure you safely invest in tax liens and deeds. Contact us today and join the buyback team.